Yes. Good morning, Chief Judge Fader, Justices. The Appellate Court of Maryland ruled correctly on, once again, my name is Chaz Ball, thank you for having me here today. The Appellate Court of Maryland ruled correctly on the issue of qualified immunity with respect to Corporal Ruby on both prongs of qualified immunity. Both as to the issue that Corporal Ruby would not have known that the specific action alleged, the shooting of a bystander in the course of trying to get a suspect, would have constituted a violation of the substantive due process of the Constitution, and that Corporal Ruby did not violate Kodi's constitutional rights. Justice Fader, your question to my colleague, Mr. Brooks, was notable, and it goes to the issue of what is qualified immunity, why does qualified immunity exist? And that first prong of qualified immunity goes to the issue that the constitutional right at issue has to be clearly established at the point of the action of the officer. And that clearly established standpoint goes to the issue of notice, that officers and officials have to know that their actions would have violated a right of an individual. The Constitution can be extremely complicated. In this case, we had seasoned trial attorneys, a seasoned judge, all go through and follow through with a Fourth Amendment claim for Kodi when there was no Fourth Amendment claim. The Constitution and the analysis of the Constitution can be extremely difficult to understand, and something that for an officer or an official can be even more difficult. So we get to this standard of it being clearly established. And when we talk about a constitutional right being clearly established, the first part of that is looking at the controlling authority, the Supreme Court, or in this jurisdiction, the Circuit Court. And if we don't have a controlling authority that goes to specifically that legal issue, that legal right, we go to the issue of persuasive authority and a robust consensus of the persuasive authority. The other circuits having a consensus that a specific action would have constituted a violation of a constitutional right. Here, the petitioners are unable to point to either that controlling authority that would have expressed that Corporal Ruby and the action that he took with respect to Kodi would have constituted a violation of substantive due process, nor are they able to show that robust consensus. And in fact, the case law that we have before us is very clear that it would not have constituted a violation of the 14th Amendment for the substantive due process. As we look to the issue of Lewis, and Lewis sort of is one of the seminal cases with reference to the issue of that bystander, or the liability that an officer would have to a bystander. And as we're clear when we talk about the Fourth Amendment issue, with the Fourth Amendment issue, it only comes into play if the officer or the official is attempting to seize that individual who is actually seized. That's when the Fourth Amendment takes issue. If the individual is not seized under Hodari D, then they're not under the seizure, and the Fourth Amendment is not implicated. But when the officer has some contact or has some interaction with an individual where there's no attempt to take that official action or that enforcement action, then the Fourth Amendment is not at issue. Here, obviously, as the court is aware, at the trial level, there was most of the discussion went to the issue of simple reasonableness, as opposed to the standards that are necessary for substantive due process. With reference to substantive due process, the court has looked to actions by law enforcement that constitute something that shocks the conscience or goes to a deliberate indifference. With respect to the deliberate indifference, if we look at those cases, deliberate indifference goes to sort of necessarily from the terminology that there be something that's deliberative, that there's some thought process that's taking place. In the cases that we have before us, and Lewis and Rucker and Timken, in both the chase cases, and I'll discuss them, or the pursuit cases, as well as the cases in which a law enforcement officer used force, had to fire a firearm, those cases don't go to the issue of deliberation. In fact, as you look at the cases that actually go to the issues of where you get to this deliberate indifference standard, most of those matters are actually when an individual has been arrested and the time that they're spending in detention before the officers take action or make sure that they're processed through.
So tell me in this case, if we were to get to this issue, why when you have a 6-hour standoff and knowing that Kodi is in the same small room with Ms. Gaines, why that wouldn't get to deliberate indifference to him and the possibility of injury to him, if you're talking about deliberate indifference?
Absolutely. And you get to this issue of sort of the 50-50 hindsight, the decision-making that an officer has at this time. We have this 6-hour standoff. We have Ms. Gaines, someone that was subject to a warrant, someone who certain individuals were left out of the house or were let out of the house. Kodi remained. Without question, there were orders from officers to let Kodi out of the residence so that he could be safe, and it would have changed the dynamic of the situation because it would have been just officers on one side and Ms. Gaines on the other side. And we're left with this position where the officers are in which Kodi, not only at this point is a bystander or someone that's left in the home, but not potentially a hostage, someone that's not being released. And given sort of the manic decisions that were made up to that point, there was certainly a concern that would have existed with any reasonable officer that this situation can go from the dynamic which it was to ramping up to potentially a murder-suicide situation, potentially someone being hurt. So there's that decision that has to happen in the moment, and the evidence is presented that Corporal Ruby was presented with an opportunity to take a shot, and at that point he did take a shot. And that doesn't go, given everything that's there, it goes to the issue of this situation could have broken in a different way at any point. It's something that a decision has to be made sort of in an instance. So given all that, there's not a deliberate indifference. Deliberate indifference cases are those in which, as I said, someone's arrested and they're held for a great period of time, and the police don't take the necessary steps to make sure that individual is processed fairly. That's that substantive due process, as opposed to here where you're looking at a moment and instant decision that something has to be made. When we get to that clearly established standard by which we talk about the liability that an officer would have to a bystander, all of the cases are an opposite of what the petitioners argue. From Lewis, when a bystander, on a motorcycle is the passenger of the motorcycle, and a high-speed chase, and the officers ultimately make contact with the motorcycle. It was clear in that case that in that matter it didn't constitute, that bystander obviously didn't have the Fourth Amendment violation, but also it didn't shock the conscience to a degree that took it up to the level of being a violation of the 14th Amendment. In Rucker, where officers are dealing with this individual who's driving in an erratic manner, refusing to stop, and officers fire at this individual and hit a bystander, accidentally hit the bystander. Once again, the court found, that the Fourth Circuit found, that didn't constitute a violation of the 14th Amendment substantive due process. In fact, the cases, and the petitioner actually cites some matters, and some, Fernandez is only in their reply brief, but I do want to address that. Fernandez, as well as, so starting with Fernandez v. Leonard, which is mentioned in petitioner's reply brief, that's actually a matter in which there was someone who was initially a hostage, who was a bystander, who the police actually shot and killed. Importantly in that matter, however, and distinguishable from any of the other matters that go to substantive due process for this violation of a bystander or a hostage's 14th Amendment rights, in that specific case, Fernandez, the hostage taker shot his weapon, he fell down, Fernandez was left standing, and it was beyond question that the officers had actually fired at Fernandez intentionally. They shot at Fernandez thinking that he was the individual. There's a distinction there between this case because this is not an issue in which the officers accidentally, or excuse me, this is not an issue in which the officers fired at Mr. Gaines, or at Kodi believing him to be Miss Gaines. This is a case in which the officers fired specifically at Miss Gaines, and as noted by the petitioner, the round actually, hit Miss Gaines and went through Miss Gaines. Similarly, when you look at the other matter that they cite, another case, Grandstaff v. Borger, it also goes to an issue where the officers deliberately fired at an individual that they believed to be the suspect, and were wrongful in that the individual wasn't the suspect, but this isn't a matter in which the officers shot at the actual suspect and missed, or shot at the other suspect and it went through the suspect. In Grandstaff v. Borger, a individual is running away from the police. He goes onto the land of someone else. The homeowner coming out to try to check out what's going on came out. The officers lost sight of the initial suspect and ultimately saw the homeowner believing him to be the suspect. The officers intentionally fired at that individual. So the distinction between those cases and this case is those cases both go to both the Fourth Amendment issue, the deliberate seizure of that individual, even if it's the wrong individual, along with the substantive due process issue. And both of those cases said, well, it goes to the facts of it. There's fact specific. There is no case of the controlling authority or of the persuasive authority, and there certainly is no robust consensus of the circuits that would indicate that an officer's accidental, and there's no question, and that's the most important issue here, that an officer's accidental discharge, accidental shooting of a bystander in the course of taking that police action would have constituted a violation of 14th Amendment right. And as we get to the complexity here, no officer, and certainly not every officer, would believe that such an action would have constituted a Fourth Amendment violation.
I have a question, Counselor. What do we make of the fact that the Circuit Court on remand didn't resolve the claim on the basis of qualified immunity, but instead said, as I understood that the facts adduced at trial did not support a substantive 14th Amendment claim?
And what's interesting is, and I think it's sort of a misnomer with a lot of the general community's period, is qualified immunity has both parts. So qualified immunity is both that the right wasn't clearly established and that the right wasn't violated. So finding that the right wasn't violated is, in essence, a finding that qualified immunity exists, because that's one of the two prongs. If, in order to be successful in a claim, a plaintiff has to go forward and show both of those prongs have been satisfied, that the right was clearly established and that the state actor or the government actor violated that right.
Okay, but that doesn't, I understand that, but that doesn't get to my question, which is, what do the Circuit Court on remand, as to the substantive due process claim, as I understood it, held that there was, the evidence didn't support it, so none of the damages of the $32 million could be attributed to that claim. The appellate court in Cunningham 2, in footnote 16, acknowledged that the Circuit Court resolved the issue on that basis, but addressed qualified immunity because the issue had been raised by the appellees or the defendants in the Circuit Court.
I'll further note.
So the issue. Okay, go ahead.
No, I'll note also that the qualified immunity is a legal issue, so the appellate court is able to address a legal issue even if that wasn't the only finding by the court.
Well, let's say a majority. I have no idea how my colleagues are going to vote on this, but one possible outcome could be that the court disagrees with you on qualified immunity. If that's the case, should it go back to the appellate court to resolve the issue on which the Circuit Court actually granted, or I guess on which the Circuit Court ruled in the defendant's favor on remand?
I'll note that the appellate court in this case, I believe, found both prongs of qualified immunity were not met by the petitioners, meaning both as to the issue of liability and to the issue of it being a clearly established right at the time of the action.
That is the end of your time. I don't see any other questions, so thank you, Mr. Ball, and Mr. Hirschfield. You have the 7 minutes you would reserve for